Hello, I'm Debujit Das, and you're watching Courts Today by LiveLaw, your essential daily roundup of the most important legal developments from across India. From landmark rulings in the Supreme Court to critical decisions shaping policy in the High Courts, we cover the issues that matter most. Today, the courts tackled a wide range of significant issues. Let's get started. Starting at the top, and the Supreme Court is once again the stage for a fiery legal battle over the restoration of statehood to Jammu and Kashmir. The Union government, through the Solicitor General, presented an optimistic picture, arguing that Jammu and Kashmir has progressed, people are happy, citing substantial development over the last 6 years and the successful holding of peaceful elections. However, the Union pressed the brakes on the statehood restoration, requesting 4 more weeks to respond. Their primary reason? Security concerns. They explicitly cited the recent Pahalgam terror attack, arguing that statehood must be considered only after factoring in these continued security threats. The petitioners immediately fought back on 2 major fronts: security and the Constitution. Senior advocates argued that the security excuse was hollow, pointing out that the Pahalgam attack happened while Jammu and Kashmir was already a union territory under direct central rule, effectively saying the incident happened under your watch. They emphasized that successful tourism and the smooth running of pilgrimages proved peace was maintained and security cannot be an indefinite reason to withhold democracy. More profoundly, the petitioners raised a dangerous precedent argument on federalism. They warned the court that allowing the center to arbitrarily convert a state into a union territory threatens the fundamental structure of the constitution. If Jammu and Kashmir remains a union territory, they argued it signals that the center could downgrade any state at will. They demanded the union uphold its solemn assurance to the court from the Article 370 judgment that statehood would be restored at the earliest. The court has given the union a final 4 weeks to provide a detailed reply, ensuring this high-stakes legal saga is far from its conclusion. This Supreme Court ruling offers a massive relief for a convict, offering a key clarification too on a principle of criminal law, that the Juvenile Justice Act applies retrospectively. The facts of the case date all the way back to 1981, when the individual committed a crime. Crucially, the convict was a juvenile at the time of the offense. Despite this, the convict was tried under the adult criminal justice system and sentenced to serve time. The Supreme Court, invoking the Juvenile Justice Act of 2000, reiterated that the determination of juvenile status is based on the age of the offender on the date of the offense that was committed. The key legal principle here is that the benefits of the Juvenile Justice Act must be applied even if the law came into force long after the crime took place, or if the claim is raised for the first time before the apex court. Finding that the convict was indeed a juvenile in 1981, the court ordered his immediate release. This decision emphasizes that the reformative and benevolent spirit of the Juvenile Justice Act must always prevail over conventional criminal sentencing, regardless of how long ago the offense occurred. In another noteworthy development, the Supreme Court today officially issued a notice on a crucial public interest litigation that challenges a rule preventing thousands of under-trial prisoners from casting their ballots. This PIL aims to empower individuals held in custody who are legally presumed innocent to exercise their fundamental voting rights. The petition directly targets Section 62, subsection 5 of the Representation of People's Act of 1951. This section imposes a comprehensive ban on voting for anyone in prison or the lawful custody of the police, making an exception only for those in preventive detention. Petitioners argue that this provision violates Article 14, that is, right to equality, by drawing an arbitrary distinction. They point out the unfairness. An unconvicted under trial, often jailed simply because they cannot afford bail, loses their right to vote, while someone facing serious charges but released on bail or parole retains that right. Historically, the law has stripped unconvicted individuals of their voting rights. This was notably affirmed in the 1997 judgment Anukul Chandra Pradhan versus Union of India, which relied on reasons like administrative complexity, the view that a person gives up their full Article 19 freedoms once they're prisoners, and the need to prevent the criminalization of politics. However, the current PIL strongly refutes this reasoning. Critics of the 1997 ruling highlight its flaws, pointing out that the court contradicted itself by discussing fundamental rights while simultaneously labeling the right to vote as merely statutory. Crucially, the argument that the ban ensures electoral probity fails to explain why a person out on bail poses less of a threat than an under trial. Since access to bail is often tied to wealth, the ban disproportionately impacts the poor. By issuing a notice, the Supreme Court is signaling that it will formally re-examine if this statutory restriction can genuinely withstand scrutiny against core constitutional principles. This marks a pivotal moment for electoral and civil rights in India for sure. From Delhi to Firozabad, where a truly alarming situation has been taken note of. A local court has been left stunned after an under-trial prisoner named Suresh was produced and submitted a handwritten letter detailing shocking allegations of torture and illegal activities within the district jail. Suresh alleged that he was illegally taken out of the jail, assaulted, and then there was rampant illegal activities involving drugs and money within the prison walls. Taking immediate and serious note of these claims, the judge promptly ordered a comprehensive medical examination of the under trial to verify the allegations of torture. More critically, the court has directed the district judge of Firozabad to conduct a high-level judicial inquiry into the entire matter. This aggressive response emphasizes the court's concern over the alleged breakdown of law and order and the violation of fundamental rights within the correctional facility itself. Shifting our focus to the Delhi High Court that just delivered a decisive ruling that puts the light back on the reprehensible practice of profit-making in private education. The case involved appeals challenging a single judge's decision which had previously quashed the Directorate of Education's orders preventing schools like Bluebells International and Leelavati Vidya Mandir from hiking fees back in the 2017-18 session. The judges reiterated that education is fundamentally a social responsibility, not a commercial venture. They were highly critical, observing that the lack of regulation allows private schools to indulge in profiteering through arbitrary fees hikes. The court explicitly directed the government to establish a robust regulatory mechanism within 6 weeks. This mechanism must strictly ensure that any fees collected are used only for the benefit of the students and the institution's growth, making it unequivocally clear that the state's power to intervene is solely to curb this misuse of funds. Next, in a landmark move toward workplace equity and health, Karnataka has become the first state in India to officially introduce a comprehensive menstrual leave policy for women employees across both the government and the private sectors. The new policy grants women employees a day of paid menstrual leave per month. This initiative acknowledges the genuine physical demands associated with menstruation, ensuring that female employees do not have to compromise their health or use of their regular sick or casual leaves. Crucially, the policy includes a significant provision for flexibility. Female employees have the option to choose to work from home instead of taking leave, provided the nature of their role is compatible with remote work. Moving on, and today we saw another addition to a spate of personality rights cases. Bollywood actor Suniel Shetty has taken a strong stance against the growing threat of deepfakes, petitioning the Bombay High Court to seek protection against their misuse. The actor filed a lawsuit specifically targeting the unauthorized use of his voice, images, and likeness to create deepfake videos and promotional content. Shetty argued that these fabricated videos are being used without his consent to endorse various products and services, causing significant damage to his reputation and a personal brand. The High Court is currently hearing his plea, which seeks an injunction, a legal order, to stop the dissemination of these fraudulent videos immediately. This case highlights a critical legal battle against digital impersonation in the age of AI. And finally, we take a look at an important bit of news as the Enforcement Directorate has issued a crucial public warning about a rise in sophisticated financial crimes, including fake summons and what they call digital arrests. The agency is alerting the public that the fraudsters are impersonating ED officials to extort money, often by falsely alleging money laundering involvement. To combat this, the ED has introduced a new verification system. All official summons will now bear a QR code, which the recipients can scan and to authenticate this document directly against the ED's official website. This measure ensures that individuals can verify the genuineness of any communication, helping protect them from becoming victims of these complex digital frauds. That's all for Courts today, and as always, for detailed coverage of every case we discussed here and more, visit us at www.livelawmedia.in. I'm Debojit Das. Thank you for watching.